deal with it in on the next day, Lordship. In their reply only, they have actually admitted.
Ladyship, we have not admitted it. We will show it on the
This
next day.
will read your ladies.
Much.
Grateful.
I am for the respondent state of Bihar. This is
Yes.
that matter of those 10,000 posts.
Submission.
Only one petitioner has come.
No.
There are several. There are 5 petitioners.
5 SLPs.
Oh,
And in one of them,
Yes,
there's about 100 petitions. 47.3.
In fact, total 1,000 candidates before this one.
In my petition, there are 427 people.
oh,
Lordship, please.
okay. Yes. Yes, sir.
May I briefly indicate, and then there is a list of dates that I will hand over to your lordships. Abhi, ek minute. My lord, this was an advertisement of the Bihar Technical Services Commission
Yes.
covering a large number.
Can you give us list of dates?
Yes, shall I give that first?
Yes, yes.
Certainly. Idhar do, udhar do. Just give me a minute.
Yes.
I will show the details in the SLP later, my lord. I'll just run your lordship through the list of dates.
Yes.
Now, my lord, the first date is 2014. The Bihar Technical Service Commission Act, my lord, by the legislature. And then on the 8th of March, 2019, there was an advertisement for 6,379 posts. Then, my lord, in 2021, there was a letter of counseling. In January 2022, there were the tentative results of selection. The next date is important. Sanjay Kumar, in his writ petition, had challenged the quality, the criteria for selection. Now, this is important
The
because
educational qualification.
the state of
Educational
Bihar,
qualification.
sorry, my lord?
The educational qualification was challenged.
That's right. That's right. Now, this is important because the state of Bihar, in response to this petition about illegality, said that the advertisement was perfectly legal and there was nothing wrong with it. Then, my lord, the next date is that the final merit list is. Now, the importance of the final merit list is that the various departments to which the candidates had to go is in that list as well. In other words, the selection had taken place, the tentative list was there was a challenge, the challenge was rebutted, and at the end of the day, a final list also indicating the designation to which they must go. All that had to happen is that the actual appointment had to be made. Now, my lord, the AICTE.
So there was no stay pending the writ petition.
My lord, pending the writ petition, the order that was passed was
Subject to the outcome.
let the process continue.
Okay.
Yeah. Then, my lord, your lordships will see that 26/2022, the state of Bihar as well as the commission filed a counter affidavit rejecting the writ petition and defending the rule. This is Rule 9. I've given the relevant pages. And the next date is the 1st of July, where the Department of Water Services, which is the nodal department here, also defended the writ petition. So as far this,
Defended the rule.
defended the rule. Now, the importance of this is the stance by the state of Bihar at this point in time was clearly that everything is proper. There is nothing wrong with the rule, and the rule is what is in question. And after this, my lord, suddenly what there is, the next few dates also defend the rule. Then, my lord, a supplementary affidavit was passed on the 13th of February by the Joint Secretary of the Department of Water Services, indicating that a number of legal issues had cropped up. This phrase is very important, my lord, because we are not very clear as to what are the legal issues that have cropped up for adjudication in many writ petitions which came for consideration. Then, my lord, in a further affidavit of 15th February, the previous selection, which was totally and completely complete, was done away with, and the state completely did a volte-face. Your Lordship will see that on the top of page 2. What they did is indented, repeal the existing rules, withdraw the requisition sent by various departments, and commence the process of selection afresh on the basis of new rules. This went to the High Court.
No, on the basis of new rules means new rules were
New rules were put into motion for
Not put into motion, sorry. Resolution would be framed.
would
Old rules have been repealed, new rules have been framed.
Not,
when
Yes, I'll give the date.
not
Pending-
on this,
pending
not on
the
this date.
repetition.
not on
Not
this,
Yes.
date.
not on this date.
That's
my lord.
subsequent
Yes,
date,
after
not
the writ petition.
So you
Ah.
had proposed to frame new
Correct.
rules.
Our
No,
committee
my lord.
had said,
Therefore,
there was,
it's-
I will point out in my turn,
My
our
lord,
committee had said.
let me
and
explain,
the
my lord.
committee said-
my friend should point out later.
Pending writ petition, you proposed to frame new rules.
Correct.
And
My lord,
the
what
old
Three
rules.
three
What they
decisions
said, my
pending
lord,
writ petition.
may I continue, my lord?
Yes, yes.
All right. I will
What was
comment-
said in the affidavit is that new rules would be framed,
Not
and
one-
they were framed after the writ petition, my lord.
For 1 minute, may I be excused for only 1 minute? My friend is here. In just 1 minute,
Okay,
Easy.
you want to.
yeah, 1 minute.
I can never deny him the minute, my lord.
You should feel obliged.
I don't know if he's obliged or not, but from my side, you're gone.
He's coming back.
Oh, he's coming back. Should we wait for him or should we
No.
continue?
He sought the permission and we have granted.
Now, my lord, comes the High Court. If your lordships will just see the High Court decision, which I'll place before you, there is no reasoning in the decision at all. All that is done in the judgment of the High Court is the affidavit is
The
recorded.
petitioners are the selectees of the previous
Unsuccessful candidates in the.
unsuccessful or successful.
No, my lord,
Here.
the writ petition,
Petition is successful.
Your-
In the writ
your ladyship is right, my lord.
Successful.
There
No,
were,
my lord.
there
No,
were
my lord,
two,
I'm sorry.
may I explain, there were two sets of writ petitions. One, my lord, challenging the volte-face. There was another one with more than 101 candidates who actually challenged the rule. The rule part, these candidates now have again turned and they actually support us, the petitioners before your lordships. Now, whether they can do so after taking a stance in the High Court, I don't want to go into.
So the present petitioners were already selected as per the new old rule.
Yes,
That's right.
Selected, merit list prepared, departments, not allotted,
Every-
all that.
all that has happened. The process is
Did petitioner before the High Court were the unsuccessful
But
candidates?
they were
They
the ones who were unsuccessful is one, and those who challenge the very eligibility of qualification in Rule 9. So if your lordship see the prayer, my lord, which is extracted in the impugned judgment on page 2 and 3, that shows it's confined to those prayers only. And the High Court doesn't go into it, and High Court says, because they have withdrawn the advertisement and they are going to frame new rules. Therefore, there is nothing to be decided in this matter.
and
my
participation.
learned friend preempts what I was going
No,
to say,
sorry.
but I will say so,
Since your
my lord.
lordship-
There is no reasoning at all, my lord. One part of it is the challenge to 9. That is not discussed in that judgment at all. The other is, here is an affidavit that they are going to do the process all over again. And the High Court records that and says, in the light of the fact that they're going to do it again, we permit them to do so. Then the matter came, my lord, before your lordships. Various stances have been taken. I won't trouble your lordships with that. May I just take your lordships first to the judgment, my lord, before I go to Rule 9?
Yes.
My lord, my SLP.
Rule 9 must have been quoted.
Yes, sir.
Yes.
The entire rules are.
But the rules and all that I will show. The background of the rules, etc. My lord, my SLP is 7257 of 2023.
Yes.
Department comes with that. This concerned the Department of Roadways. And in fact, the list says that this is earmarked for the Department of Roadways, which I'll show to your lordships. Now, my lord,
Page 1. Page 12.
वही ढूंढ रहा हूँ इतनी लंबी list of dates हैं.
Page 12 page.
Starting, my lord, page 12. And your lordships will see, as my learned friend pointed out to your lordships,
Photo page 12.
on the top of page 13,
Yes.
from the bottom, my lord, that's the bottom of page
12.
12. In the instant writ petitions, the petitioners have prayed for quashing of Rule 9, 1, subclause 2, sub-Roman 2, so-and-so department, so-and-so rules prescribing technical qualification eligibility for selection appointment to the technical post in the state of Bihar as being inconsistent with other statutory provisions in contravention to the Supreme Court's judgments and is violative of the fundamental rights guaranteed in the Constitution of India, for declaration that the said rules as being ultra-virus to the Constitution, so far amendment of Rules 9, Arabic 1, sub-Roman 3 is concerned, for any other reliefs. Now, this was the other writ petition, my lord, because we came only when after our names were there in the selection and this volte-face was done, that there was a certain error. Now, my lord, what the court does, my lord, the reasoning in paragraph 2 is the matter is relating to selection and appointment to the post of junior engineer. In this regard, the advertisement was issued on 8/3/2019. From time to time, the matter was taken up for hearing, and during the course of the hearing, we have noticed certain errors to the relevant rules governing the post of junior engineer. Now, this line is important. It just says certain errors. The judgment does not deal with the errors. It does not deal with the volte-face, where the state had entirely changed its stance. Ultimately, the state government has to take a decision to cancel. I stop here for a moment, my lord. The state government cannot be arbitrary. What is the basis of the cancellation? I have no right to selection. That has been established by your lordships. But there is also a duty to be fair, as I'll show in one judgment. The process of recruitment to the post of junior engineer with reference to the advertisement so-and-so and propose to issue a fresh or amendment of rules while rectifying certain errors which have crept into the existing rules. We still don't know what the certain errors are. To that effect, supplementary counter affidavit was filed on behalf of respondent number 4. That's the state, while enclosing a decision dated 25/1/2023 to the supplementary counter affidavit, perusal of the same as is evident that certain errors have crept into the rules would be carried in amendment to the relevant rules. The proposed action of the respondent state respondents read, my lord, if your lordship will go to the opposite page, is there in English as well. Now this, my lord, reiterates my point that in the High Court they said there was nothing wrong with the rules. All the departments, the Bihar Technical Commission, took the stance that the rules are proper, constitutional, and not ultra-virus. So let me, my lord, take your lordships to 14A.
What were the errors?
We don't know. We have no idea, my lord.
No, they must have stated in the supplementary counter affidavit.
No, my lord. And that is why the judgment then, my lord, just puts the decision. On 14A, my lord, I'll read the English version.
There is the supplementary affidavit dated 25th January 2023.
Nikalo.
That resolution on page 339. That resolution by the state lordship on the page.
No, some supplementary affidavit.
We need the supplementary affidavit. Just-
The decision was taken on 25/1/2023,
That has been noted down.
which is what has been extracted here.
Yes,
Not-
but
So,
And they only placed this by way of affidavit. This only the decisions.
what were the errors?
my lord, I will read first the decision, if I may, and then take your lordship to the supplementary affidavit. The decision that is here, my lord, the proposed action says after due deliberation in all act.
Where are you reading?
My lord, I'm reading page 14A.
14, yes.
First, I'm dealing with the decision, and then I'll come to the SLP.
Yes.
After due deliberations on all aspects, it was resolved that, in view of the legal wrangle crept in presently, the respondent process emanating from advertisement so-and-so notified by so-and-so is cancelled. Now, my lord, kindly note the words here, legal wrangle.
So that is a translation.
I know.
And let me tell you what's the Hindi.
That has been
वैधानिक कठिनाइयां.
Jatil स्थितियों.
What is it?
वर्तमान में-
वैधानिक जटिल स्थितियां.
जटिल स्थितियां.
That's all.
That's all that is said, my lord. And the translation is theirs as well. Now, my lord, in the light of these new developments, the present petitions do not survive for consideration. Accordingly, the state is permitted to carry out necessary amendment and proceed afresh to advertise for the post of junior engineer.
How many had appeared? Pursuant to
Some
this
12,000
advertisement?
or so.
But the total number of posts was 6,739.
As I went,
Three
but,
times for counseling.
my lord,
And,
about approximately 12,000, my lord.
No, the post was 6,000.
No, posts were 6,739.
Which I've
379.
indicated in my list of
List of
dates.
dates indicated.
379 and three.
And how many had appeared?
3 times
About
that.
12,000.
No.
And
No,
what
more
they,
than 18,000.
No, 3 times more.
anyway, what one of the affidavits says is 12,000, maybe 3 times 18,000. At any rate, my lord, one other exercise was taken by the commission. What they did was, they took a number of around 400 applications, and they said these were fake. Then they said that about 12,000 or so, or about 6,000 or so, were non-compliant, which means that the High Commission, the Commission had applied its mind in the process of selection. Now, my lord, para 3 is, my lord, the ratio of this. On page 14A, paragraph 3 is the ratio of this judgment. Nothing is discussed. The changes are not gone into. The justification is in paragraph 4. From the date of the last advertisement till date, almost 4 years have elapsed. Therefore, such of the candidates who are likely to be overaged with reference to the ensuing advertisement, for such of these candidates who are applicants in advertisement so-and-so, government must make a provision in the proposed amendment insofar as age relaxation is concerned. This exercise shall be carried in 4 months.
Let-
IA is disposed of.
Let us see the rule,
Right.
the infield rule.
And one more thing, was there any written examination?
No.
No, my lord.
No.
What happened was, there was a point form selection.
No, I just wanted to know whether it was after the advertisement, was there any written examination followed by
The
interview?
process, which I'll show
Based
you,
on marks of.
the process, I'll show, my lord, from an.
So the summons.
No, no,
there was no written
the answer is not an examination, but selection on
Sir, I
performance.
do understand what examination is, what is the point system. I'm simply asking you,
No.
was there any
Lord,
written examination?
I'm
So if it is no, it means no.
I was just going to explain what was
Let
done.
it be.
Because, my lord, the point system goes on your performance, as your lordship rightly pointed out, your lord, and therefore, in the point system, how they had fared academically, how they had fared in the post, all this was taken into account, and 100 marks were given to that.
But no written examination.
No written examination, no. Nor is one contemplated now, my lord. Then, my lord, they reserve the challenge for the proposed amendments. Now, my lord, my respectful submission is that this judgment, my lord, contains no valid ratio.
That we have understood. Now let us go to the rule.
I'll take your lordship to the rule.
What is the difference between the old rule and now the proposed rules or new rules?
The new rules are not on record as far as I know.
Okay.
We have filed it, my lord, and we have explained everything in I have filed a counter, a short counter on behalf of respondents 1 to 4. Every query which your lordship is raising is completely answered.
That you should have done before the High Court.
High Court.
It appears that you have not put your case properly before the High Court. You have not explained as to why you need to change the rule and what is the so-called legal wrangle.
Yes, everything is there. What happened was, under our rules, what was required.
Let us see.
Let us see the rule.
All right.
Because in the
Everything
advertisement,
is before the High Court.
advertisement 81, the educational eligibility is there.
Yes.
Just give me a moment.
And that was the problem.
But we have page adjustment. Advertisement.
Diploma in civil engineering
1 second.
conferred by the concerned
My
technical
lord,
education council.
If your lordships will come to page 80.
What is important is, I'll just add one line and sit down. I'm not disturbing
My
them.
lord,
It'll save considerable time for your lordships.
Let us-
Recognized by the All India. This was the error in the rule. AICTE filed an affidavit saying, we don't recognize anybody.
Let him.
AICT did nothing of the sort,
All
Lord.
right.
Did nothing. They simply stated what the AICT.
Yes, you may proceed in your own way.
No, my lord, if your lordships will come to page 80, my lord. This is the advertisement, and I'll take your lordships to the
Yes,
rule
that's
in a
what we
moment.
say. Page 81, educational.
81, my lord, is the educational eligibility, and this, in fact, is the rule. Now, if your lordships will come to page 122. This is the rule, my lord, as declared by the order of the governor under Article 309. The date, my lord, I've given to your lordship. Now, there's a substitution of some other rules. There's a reservation. We're not concerned with that. And bottom of page 123, substitution of Rule 9, 1 sub-Roman 3 has been altered. And the rule itself, my lord, is there on page 124. Supplementary affidavit. Technical qualifications, eligibilities for selection. A diploma holder in civil engineering from the institutes recognized by AICT, which has obtained diploma from AICT or a university. Now, this is absolutely crystal clear because diploma holders are also recognized as long as it is by the AICT, which could be non-university or university. The next part is diploma in civil engineering by non-distance mode diploma. This is important, my lord, that the stress is on non-distance mode diploma from deemed universities established under the UGC Act, provided that their syllabus of diploma civil engineering has been sanctioned by the UGC, not the AICTE.
Yes.
There's nothing more, my lord.
Procedure for selection.
Now, my lord,
Selection to the post.
I'll rule 10. That's procedure for selection. Selection to the post of basic category of junior engineer civil of this cadre shall be made by the commission on the basis of percentage of marks obtained in diploma or equivalent qualifications. Such candidates having experience of working on the post of junior engineer on contract basis under the government of Bihar or in any undertaking, corporation, body, authority, autonomous body under the government of Bihar, who accord to qualifications of the recruitment in this cadre shall be given preference by giving additional marks under sub-rule 2B. So this, my lord, is as far as it goes.
Direct recruitment.
Sorry, my lord?
It was direct recruitment.
Yes, yes.
It was not from the service tender itself.
No.
Okay.
Because, my lord, for a long time, the state of Bihar was putting engineers there on contract basis. And it is those engineers.
Even additional marks.
That's right. Additional, and because they are the ones who are now supporting. And in this.
So what is the new rule?
Now, sorry, my lord.
What is the new rule now?
My lord, if they put the new rule now, it's certainly not in my brief, my lord. They will give.
We'll show that.
Mr. Patwala said that he has already filed.
Lordship,
Page 83.
243 of my SLP.
Page 83 of my affidavit at 86.
In this case only?
Yes. My affidavit.
Otherwise, in my SLP,
You have taken up his case, so.
We'll have to open it.
Let me show the affidavit first.
Page.
83, my lord, is the new rule. Read at page 86.
No, but there's no.
निकालो यार उनका काउंटर. What the hell are you doing? ये latest counter है.
Notification dated 7/3/2023.
yes, madam.
Yes, my lord.
That's the one.
Yes. And at 86, eligibility for appointment.
Is this the right counter affidavit?
Now rule
Is rule 8.
Useless.
And what your lordship will find is recognized by AICT is missing for the qualification. That was the bone of contention in various writ petitions in the High Court. And I'll read the AICT affidavit where our rule was completely shaken by that affidavit because AICT said, we don't recognize any qualification.
But there was no decision of the High Court saying that this rule is bad.
No,
it was only on the basis of whatever affidavit was filed by AICT.
The writ petition.
You thought that is faulty.
The writ.
And that's what it was to be changed.
Yes.
The whole selection process
No,
was over.
nothing was over. That is wrong. The list was not final at all. I will address on that. 2nd April list, what they have attached and my affidavit is different. And 2nd April list was struck down by a division bench of the High Court, which judgment I have placed on the record in my affidavit. So and I am saying that their averment in the SLP that it was a final list and what document they have attached is completely misleading. So at some stage I will assist, let them make out the case they want to make it out. There is nothing was complete or final. Writs were pending. We wanted to shorten the process and find a via media. And therefore this is what we had done. And it was all being done. High Court was monitoring it.
In that case, those who were qualified as per the old rules
will still be there.
Would get disqualified.
No, they will not. No. People who were earlier disqualified and who had gone to the High Court saying we have wrongly been excluded from the list will also be included because AICT said that was right. So that list would never have survived.
So there is a small issue.
And if your lordship reads my affidavit, it will be clear.
There is a small issue.
Yes.
All these technical diplomas are mandatorily required to be recognized by the AICT.
AICC or under its rules, whether by a university or otherwise. The AICT delegates this power to the university as well. And that is the Bharati Dasan decision of your lordship. That when there is a university there, Bharati Dasan is a very famous decision of your lordships, that if there is a university, then it does not have to run its program through the AICTE. However, it says in the last paragraph, you may take into account what the AICTE says. Now, my lord, just come back to my page 124, my lord. If my learned friend is right.
Can I add one line? This is not necessary because the selection process was never finalized. That list
Let
was
us-
never final.
let
My lord,
And therefore, we
my lord,
have
if
no
my
right-
learned friend is going to repeat arguments and interrupt, my lord,
No, I'm
I have
not.
some difficulty.
I'm not.
He has already said it is not final. He is
Okay.
now repeating it is not final.
There's a-
Please repeat it a third time. It will become clearer.
So that-
Sir, please let him finish.
all right, all right.
My lord,
That is
let
the
us
point.
state our case. He will state his case. We have the right
We
to
want
reply.
the New rule, where is the new rule?
My lord, first let me show in the old rule. Because no, my lord. In the light of the interruption, my lord, your lordships will see that 9(1)A says recognized by AICTE.
That we have already.
No, my lord. He's saying that this was the mistake. So what, my lord? If the AICTE doesn't recognize, that's the end of the matter, my lord. Those people who are recognized by the AICTE will go out because they haven't been recognized. So if this was the great fatal error recognized by the AICTE, the words in A, 93A on page 124.
Yes.
Now, how is this the fatal error that results in affidavit? We've already dealt,
New rule.
or just the new rule?
New rule.
Which you got here on the left hand side.
Right.
Read rule 8.
Now, my lord.
Page 86 bottom.
My lord, as far as this notification is concerned, the earlier rules are not, my lord, relevant. We go to eligibilities. My lord. Sanction strength is there, calculation of vacancies is there, page 86, right?
Yeah, 86 foot of the page.
Next.
Rule 8.
First, let's deal with the eligibility.
Eligibility, that's correct. 8. Rule 8.
Rule 8, the eligibility shall be as follows. The candidate is required to be the Indian national, required to have a degree in engineering, civil, mechanic, electricity. So, my lord, the diplomas are out. Or the technical, I'll just come to that. Diploma comes in Rule A. Technical qualification, eligibility for selection. A, diploma holder in engineering, so-and-so, issued by the institution, recognized by the AICTE. In other words, the institution has to be recognized by the AICTE, which is precisely what, my lord, is the interpretation of Rule 9 earlier. In non-distance mode, or the equal qualification diploma holder of the course declared to be equal to the diploma under the schedule of major disciplines and their corresponding courses, appropriate branch of diploma and so. And then B, diploma holder in the handbook, my lord, top of page 87, handbook issued by the AICTE, diploma holder in so, or by the university or deemed university established under the provisions of the UGC or the diploma holder granted by the university or deemed university in non-distance mode.
So it is almost the same.
Almost the same, my lord. Now, if the grouse is that recognize, the AICTE does not recognize.
No, then or is there. No? Next.
Everything is there, my lord. अब तुम्हारा पेज 18 दिखा दें. Lord, will your lordship come back to my SLP, my lord? तुम्हारा कहाँ है जो दिया हुआ है?
Bhajan Singh.
Now, my lord, on page 87, the candidate I'm appearing for,
SLP?
my SLP, my lord, which is 7257.
Yes, yes.
This application, my lord, indicates the preference of the department that he wants to go to. And your lordships will see at page 88, somewhere 2/3 down the page, that he applies for road construction department. Then, my lord, your lordships will see the result as communicated. Page 136, my lord.
But this one is having the qualification also.
Yes,
I mean, his diploma is recognized by ICT.
yes,
This particular gentleman.
Yes,
But-
yes.
yes, no. But
Under the new rule.
see, what happened?
Also, he is eligible.
Huh.
But not what happened is that the AIC recognized the university and the Bihar University recognized many courses in Jharkhand and Bihar. So that is how the connection is made as far as my client is concerned. On the page.
What do you want to show from 136?
136, my lord, is the selection list. I'll keep quiet. If your lordships will see just above the list where it starts, it says allotted department, road construction department. In other words, this is the list. My client is number 47.
You mean to say selection was over? Even departments were allocated.
Absolutely.
And the only requirement was issuance of an appointment order.
That's right, my lord. To give marching orders, you go to that department and the process is over. Whatever training, etc., has to be done, my lord. So, my lord, the allocation has also been made. Now, my lord, one or two counters, if I may, my lord. Would your lordship,
Where the candidates inform that you are now allotted to this department or something?
no, my lord, this list had come out, my lord, and for the
Come out means, was it published?
Public advertisement.
yes, published.
On the website.
On the website.
On the
website.
On the website. So the process is over. The so-called error.
When was it done?
23rd, 2nd.
22nd April 22. 2nd April
22nd April.
2nd April.
22nd April?
2nd April.
22 or 3?
22, my lord.
Second April.
It is 2nd April,
2nd April.
2nd April, my lord.
not 22nd.
My mistake, my lord. As I get older, my recollection, my lord, becomes a little weaker.
Yes.
Once, my lord, I was arguing a case before Justice Venkatachalaya, and my clerk had not brought my brief. So I argued from memory. Somewhere after 10 minutes, Justice Venkatachalaya said, "Would you like my brief to argue from?"
Age has its own role to play.
Quite true, quite true. Now, my lord, if your lordships will see that in my list of dates, I've given the counter affidavits and the details, etc. The only other important counter affidavit is that, my lord, the last supplementary affidavit, which I'll just show to your lordships at page 329. Oh. I'm almost. Lot 330, the affidavit starts. It's a very long affidavit.
Three
7257, which starts at page 329.
Yes.
Supplementary counter affidavit.
Supplement. This is the relevant affidavit, my lord, which is the basis of the judgment which your lordship wants to see. Now, my lords, kindly skip to page 334.
Yes.
Page 334, paragraph 6.
Yes.
I'm sorry, my lord, just before that. I'm very sorry.
Paragraph 4.
Para 4 has to be read, my lord, which is on page 332. That the issue in question relates to the selection and appointment of the post of junior engineer in various departments of the state government. Earlier 2015 rules, which lay down the procedure for selection and condition of service of junior engineers, was framed at the behest of the Water Resources Department. Therefore, similar rule was also made by other works departments, that the requisition had been sent to the Bihar Technical Commission by different works department, including Water Resources Department, for the selection and recommendation for appointment to the post of junior engineers. However, it is witnessed that a number of legal issues have cropped up for adjudication in many writ petitions which came before consideration before the honorable bench of this honorable court. So there are a number of legal issues, and therefore we want to know what this number of legal issues was. Next para, that in some of the writ petitions, one of the issues under consideration is whether certificate issued by universities not having prior approval of active would be construed eligibility for the post of junior engineer. My lord, I pause. Universities do not, under Bharat Dasim, require the approval of the AICTE. That is a clear judgment, my lord, which has never been overturned by your lordships.
Yes.
Besides, there are also other issues also pending consideration. What are these other issues, my lord? We don't know. That in view of the legal issues and processes of selection for consideration from time, for considerable time, the matter has to be was taken up at the level of the Chief Secretary. In the meeting of so-and-so, it has been resolved. This, my lord, I've already read out to your lordships. I can read it again. Repeal the existing rules and frame modified rules. Withdraw requisitions sent by various departments of Bihar to commence the process of selection afresh immediately after the framing of the new rules.
So
And
this decision was taken at the level of Chief Secretary.
Chief Secretary, yes,
And the rules have been framed under 309.
under 309.
So it must have gone till the cabinet.
Well, that happens when the rules actually are promulgated.
It happened
Afterward.
after the petition was decided.
Because this does not amount to a repeal. Therefore, it doesn't go to the governor. When the new rules come, they go to the governor,
Right.
and then they promulgate.
Who appears for AICTE?
Sorry, my lord?
Who appears for AICTE?
In this one,
Yes.
Agreeing, at paragraph 4, it says that the writ application, the petitioner seek the quashing rule 19.3, which I've indicated to your lordships. Now, rule 9, it should be, not 19. Now, kindly come to page 140, my lord.
They say it's not required.
That's right. That the statements made in paragraph 19 of the writ petition is submitted that AICTE public notification for approval categorically clarified that the central state private universities is not required by the approval, except for ODL.
What is
That's
ODL?
distance learning, my lord, and online courses. This position has been confirmed by public notice and so on. This is Bharati Dasam. Now, what stance is taken here, saying not recognized by my lord, it makes no difference at all. And the notification, my lord, of the AICTE is also annexed. Second last. And that your lordships will find on page 143. The last and penultimate paragraph. The central state private universities are not required to take No, I wondered who he was. तुमको उधर होना चाहिए क्या? Just to affirm the public notification.
Where is that?
On page 143, last and penultimate paragraph on 143. Central state private universities are not required to take AICTE approval. However, such institutions have to maintain norms in conducting technical programs. As such, some of the universities are seeking approval for availing the benefits of the schemes. The central and the next one, the last paragraph, are not required to take the approval of AICTE for so-and-so programs. Application for partial approval of deemed universities has at any level can be permitted or withdrawn. So, my lord, this is the stance of the AICTE. It is not interfering with or suggesting that para 9, which is impugned before the High Court, is ultra-vires. Now, my lord, the counters in this court, shall I leave that to you? Whatever. The other. In my list of dates, I've already given the counters, my lord, of the state government, etc. I won't labor my arguments with reproducing what is condensed there. Okay. इसके रनिंग पेजेस हैं काउंटर्स के हाँ 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 इसमें जो रनिंग पेज सेपरेट I wanted to do just two things. The counter of the commission here and the counter of the state here. The supplementary counter that has come later, my lord, they will explain, we will reply then. So if your lordships will see, and then, my lord, I have to cite some cases, only paragraphs, which I will show to your lord.
Present not required, we'll call upon him, we have certain queries.
Yes, certainly.
We'll permit you to,
Just,
if necessary.
No, please you wait.
No, I just want to show these two counters.
Please wait, sir.
okay, that's all right. But I wanted to add something. That's all.
Not
My
required.
learned friend is here, let him add, my lord.
That's all right. Lord.
Is there anything new, I mean,
No,
in
just-
addition to what he has said?
Yeah, just a few things, Lord, in addition.
Let me just finish these counter affidavits. my lord.
That's okay, we have understood the point. Let
My
him,
lord,
let
this,
him explain.
I want to only add one thing, Lord, because my friend referred to a division bench of the High Court poshing.
No,
Therefore,
we
I
are
want
not on that.
that also I want to show that is
We'll
not the
permit
correct
you if
statement.
necessary to do so.
Please.
my lord, in the counter affidavit, my lord, I just want to show two things, my lord. I'll just indicate them that in the counter affidavit of the technical commission, they say that there were 12,303
Which
candidates.
page?
This, my lord, is a separate volume.
Order 5 to 7 counter
Counter
affidavit.
affidavit on behalf of 5 to 7, which is Bihar Technical Service Commission. This is the counter affidavit on behalf of respondents 5 to 7. Some very important my lord, things are mentioned here, my lord.
Because it indicates the process, my lord, which I just wanted to show to your lordships, if I may.
Which page, sir?
My lord, page 5 first, my lord.
5 of this counter affidavit.
5 of my new count.
No.
No.
This
Counter affidavit is order 5 to 7.
Your counter will reply to after you've placed it.
Page?
Page 5, my lord.
5 of what?
Counter affidavit of the
Corner
Bihar
5 to 7.
Technical Service Commission, which is a separate volume. In subpara 3, they say there were 12,303 different candidates. Question that your lordships put to. And 3 lines later, 468 candidates were found fake. In other words, the technical commission had done the exercise it was supposed to do. Then on page 6, my lord, your lordships will see that from line 3, but just after the issuance of the aforesaid merit list, I'm sorry, my learned friend wants me to read it, so I
Read
will.
from, kindly read from 4, my lord. Just
As stated
small
above,
Roman 4.
that's at the bottom of page 5. The last counseling of candidates was conducted from so-and-so to so-and-so, and in view of the counseling conducted, the commission issued merit list through letter so-and-so in respect of advertisement so-and-so. But just after the issue of the aforesaid merit list, the commission found there were some discrepancies in the aforesaid merit list, not, my lord, in the rule. And thus the commission-wide notice so-and-so stated that the aforesaid merit list has been withheld and merit list shall be published after due scrutiny of the objections. Now, my lords, if your lordships will come to page 9, my lord.
Page 7.
You want me to read page 7?
Well, continuous on
After
that.
I'm sorry. It is stated in the meantime, that's 6, my lord. In the state, my lord, we're conferring with each other, my lord, because he doesn't have to go back to this then. I'm sorry, my lord, if it creates some confusion.
Doesn't matter.
It is stated in the meantime that the Patna High Court passed its order and set aside the earlier merit list of the commission by observing that accordingly appointments were made extended in terms of so-and-so are set aside and the Bihar Technical Commission is directed to prepare a fresh select merit list granting 40% institutional reservations to all the diploma holders who have obtained their diploma certificates from any polytechnic institute recognized by AICTE and affiliated to the board. Now, the important part, my lord, here also is nothing was found wrong with the rules. All that is said here is that there is institutional, and to set aside the merit list, appointments were made in terms of so-and-so and direct a professional merit list. Now, over the page, my lord, it is stated thereafter that the commission sought guidelines from the General Administration Department of the Honorable High Court dated so-and-so, and after getting the opinion of the General Administration Department in compliance with the direction of the High Court, the commission once again conducted its counseling, dated so-and-so to so-and-so, for those candidates who were covered by the order of the High Court. This is important, my lord. It is further stated that aforesaid counseling was conducted from so-and-so date in August, and the commission was under process to finalize the merit list in respect of the advertisement so-and-so. However, in the meantime, the High Court passed its orders so-and-so. Process of selection may carry on, but the result shall not be declared without the leave of court. And then, my lord, it is stated the commission in compliance with so-and-so. We are not concerned. I'm sorry, my learned friend wants to read that as I will. It is stated that the commission in compliance with the aforesaid order passed in so-and-so prepared the final list in respect of junior engineer so-and-so and mechanical electrical on 19/12/2022 and put it under sealed cover and decided to seek permission from the High Court to publish the merit list. Then, my lord, next, it would not be out of place to say that the commission has not only allowed in its selection commission the candidates who qualified under so-and-so candidate and excluded the candidates who have not qualified under so-and-so as their institution. Now, the next line is important. As such, those candidates were rejected by the commission, and in that respect, 2,255 candidates were rejected. So the entire process, my lord, whether they were compliant or not, has taken place. My lord, I have nothing more to add.
My lords, can I add just two lines here, my lords? Before my learned senior starts.
She's for the private respondents.
I am for the private respondents who were kept out of this process merely because I am from the private university. Though in my lords, my
No, you were party before the High Court?
Yes, my lords.
They were the writ petitioners.
They were the writ petitioners.
They were the writ petitioners. In fact,
So
you are supporting.
Just give me 10 minutes. I am for the state. I have no interest.
I think my learned friend is in a hurry.
No, I have no special interest.
No, he's in a great hurry.
Great hurry.
I hope you don't have a
nowhere else.
Then be relaxed.
Yes.
Then your lordship will hear him.
Lord, kindly give me 2 minutes.
And I'm also not required anywhere else, so your lordship will hear me.
So,
my lord, may I continue, my lord? Let me.
We have heard you now. Let him.
No, my lord, there's
Understood your point.
one more affidavit.
We'll hear you again if required.
Mr. Dhawan will hear you.
All right. Now, my lord, I'll just point out to your lordships where there is on a separate file, my lord, the affidavit of the state government.
We have understood your point. Now let them answer.
Lord, kindly, Lord, give me 2 minutes, Lord. I will answer the query.
Then, my lord, let them, my lord, say what they have to say, and then I will respond.
Let
Mr. Ranjit Kumar complete what he wants to say, my lord.
Is there anything else?
No, there is something, Lord, but Lordship want to
Anything
hear.
important?
Your Lordship has some queries from Mr. Kalia.
Yes.
So, Lordship, please.
That goes to the root of the matter.
Please clarify. So I have no. I'm not coming
Very,
in the way.
very well.
I'm not coming.
2, 3
Lord,
things.
kindly hear it 2 minutes, Lord. I will just
No,
want to speak, Lord.
We'll wait for our turn, my lords. We'll wait for our turn.
Who are you?
Lord, I'm the petitioner. I am for the petitioner, Lord. Is SB civil number 2215, Lord.
We'll see. You are
I am for
supporting
122 petitioner, Lord.
You are supporting Mr. Dhawan's submissions.
Yes, Lord, but I want to answer the query of my Lordship, Lord.
Not required.
Lord, kindly see me, Lord.
Mr.
What?
Don't justify your appearance, please. When we say that, we'll again come back to you if necessary. Just wait.
Very well, Lord. Very well.
Yes, Mr. Patwale. There are 2, 3 things. Firstly, there are no reasons given whatsoever in the judgment. Secondly, in the impugned judgment, when the impugned judgment came, the rules were not amended. The High Court has taken the decision on the basis of some decision taken at the Chief Secretary level. Chief Secretary could not have taken, the decision of Chief Secretary could not be taken as the final decision till the rules are amended. Because the rules are framed under the Article 309. And merely on the basis of some decision taken in the meeting headed by Chief Secretary could not be relied upon. Thirdly, as such, there is hardly any justification given by you as to why you have cancelled the entire selection when it had already reached to the final stage. So what are your,
And the difference between the old rule and the new.
there is hardly any difference.
There is a substantial difference.
Doesn't matter, first answer first three queries.
Yes, I'm answering all three.
Yes.
Now, my lord, when we gave the advertisement,
There are no reasons.
we
There are no reasons. given
reasons are
only because some decision is taken by chief secretary.
there. It was a.
He holds the rules which were prevailing.
If I can just explain my point of view, my lord. In fact, these people have absolutely no right. The order of the High Court is perfectly justified. Just let me state a few facts to your lordships.
There,
These
final list was already prepared.
No, it was not. Not fine. No, not.
It was published on the website. That's what
That statement is not correct. I have said so in my affidavit, and I will show why it is not correct in a minute. But it will take 2, 3, 4, 5 minutes to reach there. I just cannot say it just like that. Now, let me tell your lordship what the situation before the High Court was. And where my learned friend left reading that affidavit of the commission, I want to read the next para 10 of that affidavit. Please have that affidavit. It is stated. Now, please read with me para 9 and 10 together. That is the reason. That is the problem which the High Court wanted us to solve and that we have solved. It would thousands of.
There was no problem whatsoever, it appears.
There was. The writ petition was filed by thousands.
Nothing is called out from your affidavit or other affidavits which were the legal wrangles.
Yes, it is there. I will show it. My friend is just reading one line and repeating.
Not anything is contained in the
minutes. I am going to read
minutes of the chief secretary.
My lord, minutes are the culmination of everything which had happened, which this affidavit itself shows. Please read para 9 and 10 with me. Please.
Yes.
It would not be out of place to state here. Now, my lord, before I read it, let me tell your lordships, diploma in civil engineering can either be from an institution which is approved by the AICT, technical institution, or a diploma in civil engineering can be obtained from a university, a proper university under a statute, or a deemed university. And a diploma in civil engineering can be obtained through distance education by a deemed to be university under the UGC Act. Our original rule only made eligible 2 of these 3 categories. The main category, which was a university or a private university, was excluded from eligibility. Now please read para 9 and 10 with me in this background. It will not be out of, now this is the commission telling you, your lordship has this.
The basic question is how the High Court could have relied upon the minutes of meeting headed by the chief secretary when there are statutory rules framed under 309.
So then the High Court would have had to go into the merits and decide the claim and set aside the process it would have taken. And now,
that doesn't justify the order.
Now, much more, in view of the subsequent events, that situation.
Subsequent events were not brought to the notice of the High Court.
Because they are later, after the High Court.
So on what basis High Court just allowed you to? There was no permission required that High Court granted that you are permitted.
No, that is the law. I am going to cite judgments.
No,
as an employer,
not required.
As an employer, I have a right to annul a process if I find a large body of students.
There was no permission sought by you. Then now we require to amend the law.
No, that is what we present.
Therefore,
so the High Court, that is what we never did it ourselves. Our decision was placed before the High Court. The High Court said we have seen the decision, we are satisfied with the decision, and thereafter the rules were amended. Please see.
Court has committed.
Please see page 8 and 9. Please see page 8 and 9.
Yes.
Just see, because it will be, those writ petitions will have to be decided on merits, and there were interim orders in place.
High Court have to decide it.
All right, then it will again postpone the one way can be let this order be set aside. Let those writ petitions be decided on merits.
No.
Whatever will happen will happen. Just kindly see now para 9 and 10.
Yes.
It will not be out of place to state here that the commission.
9 and 10, page 18.
Yes, page 8 and 9.
No, you are reading counter affidavit.
Counter affidavit on behalf of the commission.
5 to 7.
Yes,
5 to 7.
I am first reading that.
Para 9 is at page.
Roman 9 page 8.
Oh.
Roman 9 page 8. Roman 9 page 8.
Yes.
Roman 9. It would now, I am now addressing the problem in the rule. Then I will address whether the list was final or not. It was not final. What is shown to your lordship?
You are justifying your action, which now you have taken.
No, I am not. I am not. I am now just.
Relevant.
Yes, I am at. Yes, I am at that time. I am. So therefore, I am at that time now. Please see 9 and 10 for that time. It would not be out of place to state here that the commission has only allowed its selection, in its selection process. Now, this is the commission saying, out of thousands who applied, whom have we allowed to participate? It would not be out of place to state here that the commission has only allowed, in its selection process, candidates who have qualified in respect of clause 9(1)(3) of the advertisement and excluded those candidates who have not qualified the condition of clause 9(1)(3) as their institutions were not approved by AICTE. As such, those candidature was rejected by the commission, and in that respect, about 2,255 candidature was rejected by the commission. This is the position in the High Court. The High Court was hearing a writ petition filed by these 2,255 candidates. And I'll just take your lordship to that writ petition. They have attached it with their SLP. It is stated that aggrieved by the action of the commission in rejecting the candidature of the candidates who were not conforming to the specific clause 9(2)(3)(i) of the advertisement bearing 1 of 19, various writ applications were filed. The lead case was in the name of Sanjay Kumar Chauhan. In those writ applications, all those writ petitioners who got their respective diploma degrees from institutions which were not approved by AICTE. It is stated that in the aforesaid batch of writ petitions, on behalf of the commission, counter affidavits were filed, and government also filed counter affidavit. Finally, a supplementary counter affidavit was filed, where government informed the High Court that the competent authority has decided to cancel the advertisement. I'll come to this later. Why did it happen? Now come back to the SLP. Let us go back to the stage before the High Court order. Now kindly see the writ petition which was filed at page 94. This is now we are before the High Court order. We are at the stage when a proceeding is pending in the High Court. And what the High Court did, what your lordship has to see, is it a possible course of action which could have been taken by the High Court or not? The other option is let it be set aside. These writ petitions will get restored. They will again be decided whether these candidates are eligible or not. And what happens to the fact that we have, what is our amendment to the rule? Let me just make one statement and then read the petition. When these writ petitions were pending, the state of Bihar filed an affidavit supporting it. But AICTE came and filed an affidavit saying there is no need for approval by us for those deemed universities and for those private universities and universities. Why you have wrongly excluded those students. We were presented with a big problem. High Court passed an order saying you have created this chaos, please do something about it. In the meantime, there was one more matter pending of 40% institutional preference. In that writ petition, this 2nd April list gets quashed. Then this list
is not being called out from any of your affidavits.
My lord, it is there. I'm going to read it. I'm going to read it, my lord. It is a question of fact today. I'm reading it. Now please see page 94 with me. The writ petition in which this 3411 would possibly be one of the writ petitions decided by the High Court with this order. Is that right?
That is
page 94, the SLP which Dr. Dhawan was arguing, my lord. This annexure is with his 3411 is the lead petition which is decided, and that is this petition at 94.
3411 is 47.3.
No, Shashi Bhushan Prasad is the lead petition.
Doesn't matter. We are taking up SLP 7257.
Yes, I am on that only.
Yes.
I am on that.
Page?
Page 94 is where the petition starts. Now please see it at page 111. Please see the prayer first at page 108. The prayer was please quash the rule.
Yes, that has been quoted.
The prayer is for quashing rule 9(1)(3)(i). As being inconsistent, just kindly see page 108, the first prayer. For quashing rule 9(1)(3)(i). I'm sorry, my lords.
Yes.
Justice.
Yes, then.
For that is 1(1)(i). For quashing rule 9(1)(3)(i) of the Bihar State Water Resources Department, so and so rule 17, prescribing technical qualification of eligibility for selection appointment to the technical post in the state of Bihar as being inconsistent with other statutory provisions in contravention of the Supreme Court's judgment and violative of fundamental rights. What is their grievance? Their grievance is at page 7, para 7 at page 111. That though the petitioners, page 111,
Yes.
that though the petitioners are eligible for appointment on the technical post on the basis of qualification possessed by them, that is diploma in civil engineering, from the state private university, they are not being considered in terms of the relevant provision of the rules prescribing eligibility qualification, which mandates that institutions from which the aspiring candidates acquire qualification require to be recognized by the AICTE. Our rules only created 2 columns at that time, and I'll read it again. First column said, if you are from a technical institution recognized by AICTE, or if you have done your degree by non-distance board from a deemed university under the UGC Act. But all such universities, whether statutory or private, which were in the state of Bihar and all over the country giving diplomas, those students were thus placed outside the purview of our rules, and the commission rejected all their applications. Those students were before the court. When those students were before the court issued notice and then made an order at page 134.
Please wait.
We have tried to solve a problem, my lord.
Yes, please.
Apart from this, my lord, there were a series of other writ petitions pending before single judges also. This writ petition enclosed an order of that. Just kindly see page 133, 134 now. What on 23rd June 2021, what was ordered by, what was the view of the court? Now, in these writ petitions, when we defended them, Dr. Dhawan is right. We filed a reply defending them. That is the correct position. Now, but AICTE filed a reply saying they are wrong. We don't give approval. These universities and private university degrees are as good as any other degree. Then the court passes an order. Please read that order at 134.
Rightly or wrongly, you had framed the rule. The court had to take decision that this rule is ultra vires.
So today we have withdrawn that rule. The question is, do I have the power as
Today, we are not talking about today.
Lord,
We are talking about the day when the petition was disposed of.
I do understand.
Without any reasons, and on the basis of so-called decision.
Lord, but then merely sending it back is going to serve no purpose. Your lordship may take a view that what is to be done now. These 2,500 people who were eligible. Now, Dr. Dhawan is arguing today that no approval is required. So he's conceding their eligibility. If he's conceding their eligibility, then the merit list is bad.
1 minute.
My lord, even in private universities,
My lord,
permission is not required.
What applies to
Bharati
me?
Dasam was a private
So,
university.
my lord, what applies to me
I'm-
applies to him also.
How many?
He doesn't have, he cannot.
My lord, I don't do it so frequently.
That's the difference.
But
But
after that,
how many posts are vacant as on today?
today, post vacant are 9187.
9187.
But the problem is, my lord,
Is it possible to accommodate all?
No. You have already selected a particular.
It's-
You have already carried out.
6,000.
My lord,
Sir,
but these are
but you
given
have
enough time.
extended-
You have selected a class of people. You have already selected a class of people. Certain people were excluded. So for them also, you include them in the process of selection.
So, my lord, my point is, I am not going to say no just now. Unless I ask the state and come back, I'm not going to say no just now on my own. So, your lordship have made an observation. It is very important, and I have absorbed it. But as I seek instructions on that, one point is there a final list? There is no final list. On that, I'll address your lordship.
For all purposes, the list was final.
No, it's not. Now see P7 and then see my counter, the real P7. This is not the real P7, what they have attached. This is a very misleading document, if I may say so. Please see P7.
Page 136.
Yes, now have my counter in this court and see the same document which I have filed, which is the correct document at page 41. Please see this.
Subsequently, my lord, the commission did it in
Subsequent is nothing. Mr. Ranjit Kumar, please.
Permission. I'm sorry. My friend is now misleading.
I'm sorry.
I read we read the commission's affidavit.
There is no question of any
permission.
There is no.
They said
There is no question of any misleading. My lord, let me make out.
it is misleading.
No, every time I make out something,
No,
my
what?
friend will jump up and say misleading.
As if you never interrupted us, please. According, my lord, the 2nd April 22 list was kept back because there were discrepancies. Thereafter, in between, they say that the High Court stay came. So therefore, we did not. So we prepared a new counselling. There was new counselling done, and that your lordships read in para 8 of the Bihar Technical Service Commission, Roman 8, just now, my lord, in the affidavit, that, and we wanted to publish it and sought permission to publish.
So it's never published.
No, so therefore
it's not final.
So
therefore,
kindly read this paragraph 8.
I will read it, my lord. I will read it. Let my friend.
So my friend to say that there was no list, so therefore my friend is wrong.
Let me make out.
And the Technical Service Commission is a statutory body.
Shouting, I can't help it.
And a statutory body which is required to do this pilot selection.
Lord, may I just make out my case that the list was not final?
Lord,
Now,
I
kindly
promise not to be double-barreled, my lord.
My lord, it's first of all, my lord, please see the document at page 136. That is the most misleading document. I said it earlier. I'm going to repeat it again. My friend will again jump up, but that's another matter. Now, please see the real document at page 41, the 2nd April. Please see.
You want us to see 136?
136 is what they have attached as P7, merit list number so and so.
Yes.
Now, there is, just kindly see now the real document.
It is said that allotted department. So
Yes.
these candidates have been allotted.
Yes. Now, please see this P7 document and now see page 41 of my counter.
Which counter? High Court.
Which counters?
Supreme Court. Here.
Counter
Affidavit on behalf of respondents 1 to 4. Filed by Niranjana Singh Malot. The name of the counsel. At page 41. And I will read the same affidavit which Mr. Ranjit Kumar is referring to show that makes it crystal clear that there is no final list even up to today. Page 41.
41 is advertisement.
It is 2nd April 2022, the same document.
It's some advertisement.
Yes, that's the real list. There is no such document like this which they have filed. God knows from where they have interpolated it. Now, please read it and I'll show the.
Interpolated.
Anyway,
This can't be.
Anyway.
This must be your document only.
No, it's not in this format. Now, just read it, my lord. Please read what it says. Necessary notice, Government of Bihar. Advertisement number 1. Page 41, my lord.
Page 41 of his counter affidavit.
Counter affidavits for 1 to 4.
For the state, my lord, which I wanted to read.
No, but that is
This is R4.
R4 is some letter dated 2/4/22.
So that is the my lord list my friend is talking about.
He's talking about.
2nd April 22. No.
Talking about this only.
No, but what you are saying is something.
Same thing, my lord.
That's what-
Same thing. 2nd April.
This is the covering letter attached along with this P7, which has been held back from your lordships.
It's
And-
not held back. It is in my SLP. It is very much there. So don't say.
So my lord, kindly see, I am addressing one SLP. I will address the other also. Now, please have this 2nd April 22 letter. Advertisement number 1 of 2019. The integrated advertisement was published in the light of the requisition of the vacancies received for appointment on the post of junior engineer. Accordingly, the integrated merit list was prepared after scrutiny of objections received from the candidates participated in the counselling held in various phases. All candidates were selected as per order of merit under 60% category, etc. The following candidates were selected allotting department category wise according to the concerned department, options given, etc. Now, most important, please come to
Now,
page.
even according to you,
Yeah, you're admitting everything.
Now, please come to page 50.
no, but how does this help you?
No, because objections are invited. We are.
After considering the objections, that's what you said.
No, not after considering.
That's what you just
This
said.
document,
One
this
minute.
document invites objections. Page 50 now.
No. Accordingly, integrated merit list was prepared after scrutiny of the objections received
Correct,
from the candidates
correct.
participated in the council.
That was during counseling. During counseling, it
So-
was done. So now this list is there. Now see page 50. 50.
Yes.
It says, it shall be open to the state to complete the process of selection. Order of appointment to be notified that their appointment shall be subject to final outcome. The merit list shall be effected in the light of the order. Now turn over the next page 51 and 52. Where objections are invited against this list, 4-4.
Now they don't
If-
connect the list with this notice.
Well,
Not
this is a way of arguing in the
I'm
Supreme Court.
sorry.
One line I say and one line he gets
There
up
is
to
a
contradict
complete
it.
list attached.
I'm very sorry to say that.
So they also
No,
suppress.
Mr. Patwalia, when you say that what they relied upon is interpolated,
Ah.
is not correct.
Not correct.
No,
No,
what I'm saying
no.
is page 51, 52.
No. That may be the subsequent.
Now please see.
You have to annex the list, merit list.
Yes.
I have annexed it in my SLP.
No, that was there. Here
Yes.
Page 136.
So, my lord,
My lord, in
my
the other
friend-
SLP,
my-
more lists are also there, my lord, which
Mentioned
my
by
learned
this-
friend will show to you.
This necessary notice, in the necessary notice, which is at page 51.
51.
You are making a mention of a particular merit list. It
Correct,
means
correct,
Merit
correct.
list was published.
But we are saying
And
after.
where is that?
My lord,
Merit list was
it
published.
is this only, 2nd April.
The
Now
one,
we are-
the one which they have filed.
Yes.
That's right.
So, my lord, just see page 51, 52 now.
Said it is
Please,
acceptable.
one, say, no, my lord, I mean, nobody can argue a case like this, my lord.
Okay,
Where one
Mr.
line,
Ranjit Kumar, now don't disturb.
every time I say a line and they feel I'm making some progress. They feel. Now please see page 51. All right. Now please see page 51, 52. Not this way I cannot, because then two people will get up and say,
That's
keep
what
on
you did.
objecting. That's what I.
Mr.
Yes.
Kumar, now please.
Now please see page 51 and 52. If anyone wants to file objection or complaint in reference to the advertisement published so and so, he may do so.
Merit list published.
Only after disposal of objection or complaint, the recommendation shall be sent to the department for necessary change. So then page 52, after amendment, if any, post disposing of, see page 52, in the office and email, it shall be published once again on the website of the commission. Now, most importantly, please have page 53 onwards. This is a batch of writ petitions which were pending in the High Court.
So what was the
Where-
list? Which was the list?
Where now, just see one paragraph. Just see page 74.
Yes.
In this judgment, my lord, 40% institutional reservation was under challenge. Now, what happens at page 74 is, in the said view of the
That
matter.
was a different issue.
No, but the list is set aside. Now, please allow me to read 2 pages, 74, 75. In the said view of the matter, amending Act 17, just see page 74, the para in the lower half of the page. In said view of the matter, amending Act 17 is read down to the extent that 40% institutional reservation shall be provided to all affiliated and recognized polytechnic institute by the state AICTU within the state of Bihar. Merit list is to be prepared accordingly. Then next para, last para. Accordingly, appointments made to extent in terms of Rule 4 are set aside. The Bihar State Technical Commission is directed to prepare a fresh select list granting 40% institutional reservation to all diploma holders who have obtained their diploma certificate.
Was it in respect of the same list?
Yes, yes.
From where do we
The
get
commission, the board, now see the board's reply.
From where do we get that?
Yes, yes. Please see now reply 5 to 7.
No, no. It must have been mentioned in the present.
Yeah, the
order
reply
itself.
is in the present case only,
No,
madam,
no, no.
which was just read.
In the order itself, they must have talked about
The list, I'll see.
which list they are setting aside.
Yes, 1 minute. I'll just see. Because the commission it makes it clear.
No, 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 not commission. The order must make it clear.
Advertisement of issues. Just 1 minute.
Which list they were talking
Yes,
about?
I do understand what is falling from your lordships. I'll see whether the date is there.
No, no, first page 62, the reliefs have been mentioned.
The writs may have been filed earlier, my lord. List would have been later, but let me just see. Says to declare Rule 4A of the rules.
What is the advertisement number? 1 of 2019.
Yes, yes.
So it is there.
It was
It is
there,
there.
but,
For quashing clause,
but which select list?
it's the same, my lord. There is only one select list, my lord.
They must have,
The commission says
by
so.
that time, the select list must have been published.
The commission, no, just 1 minute, my lord.
19
112.
No, it can't be because this is, this
What is the
order
date
is
of
of
this order?
19 April and
Yes.
the select list of
Was 2nd April. my lord.
2nd April.
Yes,
It-
yes.
It could not have been so.
It is, my lord. 1 minute. The commission will probably say so, my lord.
No, no.
We've said so. Yes, please see my counter. I have said so. In my
No,
counter.
no, well,
Please see my counter, my lord. I have said so. In my counter.
no, 1 minute. See, this
Please see
advertisement one
page.
2019 was in respect of other posts also. So this is not the same post.
1 minute. All junior engineer. Let me just check.
No, no.
Let
But
me-
the appointment of technical assistant.
No, all junior engineer. It's the same. There's only one
No, no,
post.
in the relief.
Page 80, my lord, it's
in
only
the-
one post.
In the relief clause mentioned in para page.
But I have said so, I can file an affidavit. I have said so at page 13 of my counter before your lordship, that this very list is set aside, para 18. I have said so. And they have filed a rejoinder, there is no denial. I will read the rejoinder of
In
it.
fact, more than one advertisement, two advertisements were under challenge in this.
Yes, but the advertisement 1 of 19
Is
is
there.
only junior engineers where they have applied. That's all.
Then the other one is the date is
They wanted institutional preference. Their case was of institutional preference. But the point I'm making is the list never got finalized, my lord. The list never got finalized.
against this no SLP.
No, I don't think this judgment is final, my lord. And then there is a second, or may I just read, my lord, from para?
Has to be an date of the merit list. which has been
2nd
set
April,
aside.
2nd April.
That's right.
Hold on.
From
In the order, it is not there.
Ah.
Para 18 of my petition, I say so. Kindly ask them. It's the same list. There is no other list. The commission says now, just have page 12 of my counter. Please have page 12 of my counter here. Page 12 of my counter before your lordships. Para 17. Page 17. Para 17, page 12. Once this very list gets set aside, where is the question of any right? Them and both come out with an integrated merit. Correct. Can I kindly draw your lordship's attention? Page 12, para.
Page 12 of?
My counter before your lordship's here, my lord.
Was there any appointment made earlier under these rules?
Earlier. Sure.
Because these rules are of 2017.
Sure.
No. 2015
Never.
rules amended in 2017.
So, my lord,
I
am aware of that, my lord. I would have also told your lordship. But no, I am instructed by the officer who is here that no appointment has been made. Sure. No, sure. There is no appointment. And the change is what we have added, clause 3 is only making these diploma from university and private university eligible, who were the writ petitioners before the court. Now everybody is eligible. Today, if we are to, they have also got relaxation. Today, if we have to make a combined list, they will be there, these people will be there. We have 10,000 posts. So therefore, one way can be, I can come out with a combined list.
I mean, that is the
of integrating everybody and show it to your lordships, and your lordship can see what is the effect of that combined list today. Because we also need people. It's not that we don't need people, and where are we going to get them after all? They are the only pool we have to, if we tomorrow we give an advertisement, they are the only people plus both. The only problem is the people who have become eligible in the intervening period. Their rights are going to get frustrated. That's the only problem. Now, otherwise, my lord, my case before your lordships is, the list is not final. Whether I succeed or not, my lord, that is in your lordship's hand. But the state's case before your lordship is, list got quashed. Then
you are sure that this order was not carried forward?
No, my lord, this is not carried forward. No, the commission in its affidavit says after this order, I did another round of counselling. Then I prepared some list, but I kept it in a sealed cover because by the time the High Court injuncted appointment and said I was planning to go to the High Court to apply for vacation of the sealed cover. So that's the commission stand. So that list was set aside, my lord. In any case, I can also be more sure of that. Oh. Now, my lord, I am told that the new rules now envisage a written examination also. The merit list of candidates shall be prepared on the following grounds.
When those rules were amended or had come into force?
So those rules have come into force now, but your lordships have laid down law, chapter and verse after 2023 that we are within our rights to not fill up the post if we are contemplating to amend rules. That is the judgment state of Himachal Pradesh on a review of the entire previous law, starting from yes, that is 2023, my lord. I will get it. I just get the state of Himachal Pradesh. That 2023. Yes, that's the state of it.
Those judgments are certainly there. That mere inclusion in the select list does not create
correct,
a right.
Correct.
But it's okay. But we have to see the broader.
I can, if your lordship, if it has fallen from your lordship for some via media, I can certainly seek an instruction and discuss with the chief secretary at his level only.
If according to you, no appointment has been made since 2015 till this 2024, that is 9 years.
Since 17.
9 years.
Amendment was in 17.
Amendment was in 17. The main rules were of 2015.
No appointment has been
9 years.
From 50. Yes, that is why look at this.
When this exercise was over, now you said that no.
10,405 are our total vacancies, out of which 9,187 are vacant. We have no junior engineer. And from the lower post we can't promote because then it will create a huge a problem there also.
So there are 2 channels for appointment.
As junior engineer under the rules, in some states it's only direct, but there is assistant engineer from
Only one channel.
Promotion.
Only one channel.
This channel.
Yes, so only direct for junior engineer, only direct.
There is no question of.
Correct,
property.
your lordship is right, only direct. So, my lord, the list is not, my lord, one other way is allow us the new process. Let us see how many of them get selected. The ones that you keep this pending.
No, we can just draw a line that those who are eligible as on the date of impugn order, they will be considered by you. Both the petitioners and
The
the
private
private.
That's the easy way out.
university. Because today we have become overage also, and after 9
For-
months they come up with this new criteria.
Or that age relaxation has been granted to you.
That's correct, my lords. But then we are those who even have more marks than some of these people who have the AICT approval or the other universities. We have more marks than them.
Let him take let him.
We are
My lord,
verified.
my instructions today are to, but I don't want to of my own also, because it's very sensitive. I mean, I am being constantly sort of speaking, and the chief secretary himself is very, very interested, because he says there is a huge problem on my hands. So I am not going to make a commitment to your lordships, my lord, which will embarrass me at some later stage, or I don't want to put it on my learned friend also, my lord. Kindly give me 4 or 5 days, 3, 4, 5 days. I'll talk to them, and then ultimately let me see if something can be done. Otherwise, I can assist your lordship on merits. Your lordship can take a call, my lord. My
Because
case.
there is no point. And the old rule. The date of impugn order.
Accommodation means, if you are, we say, we cannot just give appointment to everybody, but accommodation means if we have to consider, let me not make any statement today. Let me not say anything today.
But may I make one
Let me just get a proper instruction as to how much and what the state is going to do, and then your lordship will take a call on that.
May I make one submission? Just one respectful submission. Is that under the old rules or the new rules, so far as we are concerned, our qualification has not been done away.
That is correct. They are eligible.
So therefore, my lord, if I am eligible and a list is prepared, why my lord, that should not be given effect?
Because certain people who were otherwise eligible
Have been
were excluded from the process of selection, keeping in view the ICT affidavit.
My lord, they were not.
That's the point. So let him take instructions. If
No, I'm not coming in the way. My lord. I'm
because a
sorry.
large chunk of
I'm not
people
wanting to
were
do that.
excluded, and that's the problem.
I'm only saying, my lord, that we are eligible.
They were also eligible, and therefore
They have been made eligible
the
now.
validity of Rule 9 was challenged by them.
Correct.
The High Court should have decided that matter.
Correct.
High Court has not decided the matter. They realized their mistake and they amended the rule,
Correct.
making everybody
Correct.
eligible.
So, my lord,
That is on merits, my
I'm not coming in the way of a third category.
That is why please permit him to seek instructions.
I'm not coming, but I'm saying, my lord, so far as we are concerned, there is nothing wrong with us.
Under the category that my lord is referring to, my lord, that is 47.3. Those set of.
No, at the time, relevant time when the old rules were enforced,
Yes.
you were not eligible.
My lord,
We were eligible.
You are.
Her
My
client,
client.
Our
Those
Petitioners.
two petitioners before the High Court. Correct.
Now let us.
once they
explore
participated.
whether they also could be accommodated.
Because the vacancies have increased.
What they say in their writ petition, Lord, if I may just say one more sentence. They said that we applied on the portal and our applications were accepted, but then they were later rejected because of the rules.
We were
Is
given
what they have stated in their as a writ petition, I'm only bringing to a lot.
And that is why they have challenged the rules.
That's why we.
So then they challenge that.
You know, my lord, when the entire exercise was done. My lord,
And your lordship, they participated in the process and then they're challenged. They're peculiar to challenge it.
my
My lord, may I just make one submission, my lord? My lord, the earlier advertisement concerned 6,379 posts. We are certainly eligible as far as those posts are concerned. Now they want 10,000 posts. As far as we are concerned and we're compliant, my lord, we should be offered the jobs because nobody, even after
There is a possibility.
even after the
There's a
vetting
possibility.
process.
There's a possibility
Mr.
that they
Dhawan.
might score more than you
I
in
have-
the process of selection.
It's on instruction.
No, my lord.
No problem.
My lord, my say.
What will happen to the order by which this list has already been
Struck
confirmed?
down, yes.
Lots
No,
of
so thereafter,
Lord, may I suggest?
thereafter the commission said that after it was done, we drew up a new list as per the High Court order. That
And-
is what is mentioned in
And that is in a sealed cover.
And all that they wanted.
Nobody knows it's in a sealed
It is
cover.
there, my lord.
It's never seen the light of day.
Seal
No,
cover.
it is in seal cover. The commission will inform.
Where is that seal cover?
Lord, that I can't, my lord. I can't. I'm not
My
privy.
lord, therefore, my lord, the process was.
It's for the commission.
May I just read
I will-
page 8, para 8, my lord. Just kindly permit me 1 minute. Page 8, para 8 of the commission's affidavit.
Sir, let us do one thing. Please permit him to see.
I'm not coming in the way of.
Otherwise, my friends.
No, my lord, because your lordship was
I'm
looking
not
at
coming in the way.
proposals. Because your lordship was looking at a way out proposals. My lord, that is why we have intervened.
No,
I've been a very good boy throughout, my lord.
All that we are.
Certification.
Just my friend will keep that in mind. The post at 6379 earlier point. 2225 as per the commission's affidavit were rejected on the ground of this technical qualification which they have now added in the rule. If your lordship that were added, it comes to 8,500 odd or 600. Now post they are saying is 9187 today. So therefore, if their posts are still more, then after a
No, you can't fill up. Only the advertised post can be filled up. They have no right against the rest of
You
them.
have to see.
I'm just
There are other people who have qualified in the last 4
You
years.
have to see the select list prepared subsequently after High Court's order.
yes.
That has been prepared by the commission
Yeah.
and kept in seal cover. Where is that seal
The
cover?
commission should
We will
inform
get
you
into
That is the final list.
because
That is the final
the
list.
question will
And the
then.
seal cover.
Lord, then,
Not on the record.
then
It's not on
the
record.
point is,
It's on record.
their,
No, it is in seal cover, my lord.
their argument that 2nd April vests a right, that argument is demolished then. There is no 2nd April vesting a right. 2nd April stands.
No, my lord.
If it comes to, we'll decide whether.
Correct,
that had-
correct. So the moment they are conceding that 2nd April is squashed.
Second April will never quash, my lord. Except that they are elaborating a
It
new
was
rule.
quashed.
There is no quashing, my lord.
That was caused by the subsequent order of division bench.
That's right, my lord.
Yes,
Without any reasoning.
for different reasons.
For entirely different.
Not
Yeah, but the fact remains it was squashed.
not for
And
the,
I may point out, my lord, private universities are not required to get permission from the AICTE.
So he's
Bharati
making out their
Dasam
case.
was a private university, my lord.
He's making out their
It
case.
is their mistake, but I don't want to go into merits right now, since your lordships are looking at logistics.
Why you're getting sandwiched between them?
Without.
No, I'm talking about senior Tripathi ji.
No, that is because I wanted to make a mention, my lord, in item number 55. That it's a very short.
Your lordship,
Let us finish this.
lordship may give a date in this matter.
Any-
Your lordship.
Just after 3 or 4.
after.
3-4 days.
After
2 weeks or so.
making submissions for some time.
2 weeks.
The learned senior counsel, Mr. Patwale, for the
Yeah,
respondent state,
I am here.
6 time to take instruction. Should be specified.
Oh, but your lordship may say just this.
Instruction.
Yes.
Full stop. He may also inquire as to the seal cover produced before the High Court.
No, not before the High Court. Inquire about the list in a seal cover which is mentioned,
Which is in the commission.
mentioned
Page
in,
8. Page 8, small Roman 8 para.
mentioned in para 1,
List in seal cover, mentioned in
para 1, sub para 8 Roman of the affidavit filed by the commission.
by the respondent commission.
The same advocate on record is for the state and for the state.
I am not denying it that I will get that
Comma,
instruction.
which appears to have been
My friend has.
prepared subsequently.
Lord, the date is also given 15/12/22 and 19/12/22. The date is given in that para.
But that
Subsequently,
list in the seal.
after the
cover,
list
no right.
prepared on 2nd April 2022.
Lordship, please.
I'm obliged.
List-
One-
They say they followed the judgment of the division bench.
List
Then they
on-
prepared it.
Okay. Should we keep it on 18th? Because I don't know, 17th, next 17th is,
Miscellaneous.
must be miscellaneous.
18.
18th,
Let it be on 18th for the time being.
all right.
Item 51, that contempt matter, Mr. Joydeep is here. This, Lordship,
You will have to-
after 22nd, on the 22nd of October.
We must talk about.
Nine.
Oh,
Yes, because there are problems. I am going
Yes,
to
sir.
wait for a
Grateful. Not
22nd.
Very grateful.
Lordship speaking about 22nd. Can it be at 2 o'clock? Otherwise we'll.
why are you verifying? You have said 22nd October, that's it.
Well,
Item 49, I appear for the Calcutta Port Trust. And our difficulty is that I am unable to set up way bridges. This is an international port. We have moved an application for that limited permission.
Rest of the matters after 2-3 weeks.
Manoj,
Difficult to give date. So many
My whole
holidays in